Welcome back to online classes. Dear students, today I am going to discuss with Indian Penal Code. Okay, under section 376 subclass 1, punishment for rape. Under this act, whoever, except in the case provided for in subsection 2, commits rape shall be punished with imprisonment, that is rigorous imprisonment of either description for a term which shall not be less than 7 years, okay, but which may extend to imprisonment for life and shall also be liable to fine as usual procedure. And sections 376 subclass 2 explain about A. Being a police officer commits rape under class 1 within the limits of the police station to which such police officer is appointed, or number 2, in the premises of any station house, or 3, on a woman in such police officer's custody or in custody of a police officer subordinate to such a police officer, or B, being a public servant commits rape on whom in such public servant's custody or in the custody of public servant subordinate to the public servant, or C, being a member of the armed force deployed in area by the central or a state governments commits rape in such area, or D, being on the management or on the staff of jail, remand home or other place of custody established by or under any law for the time being in force, or of a woman's or children's institutions commits rape in any inmate of such jail, remanded home, place or institution, or E, being on the management or on the staff of a hospital commits rape on a woman in that hospital, or F, being a relative, guardian or teacher of or a person in possession of trust or authority towards the woman commits rape on such a woman. G, commits rape during communal or sectarian violence, or H, commits rape on a woman knowing her to pregnant. F, commits rape on a woman when she is under 16 years of age, or I, commits rape on a woman incapable of giving consent, or K, being in a position of control or domains over a woman commits rape on such woman, or J, commits rape on woman suffering from mental or physical disability, or M, while committing rape causes grievous bodily harm or maims or disfigures or endangers the life of a woman. N, commits rape repeatedly on the same woman, okay, shall be punished with rigorous imprisonment for term which shall not less than 10 years, but which may extend to imprisonment for life, which shall mean imprisonment for the remainder of that person's natural life and shall also be liable to fine. As per the section, the explanation for this act, for the purpose of this subsection, number A, here armed force means naval, military and air forces and includes any member of the armed forces constituted under any law for the time being in force, including the preliminary forces and any auxiliary forces that are under the control of the central government or state government. B, hospital means the precincts of the hospital and includes the precincts of any institution for the reception and treatment of persons during convalescence or of person requiring medical attention or rehabilitation. C, police officer shall have the same meaning as assigned to expression police under the Police Act 1861. And D, women's or children's institution means an institution whether called an orphanage or home for neglected women or children or a widow's home or an institution called by any other name which is established and maintained for the reception and care of women or children. Okay, students, and also the prior to substitution by section 9 of the Criminal Law Amendment Act 2013, the law was amended in the Criminal Procedure Act at the date of 2013 with effect from 3rd February 2013. So section 376 stood as under this ingredients, under this section. Okay, the new structure is framed as per the section. The old section is already, as per the law, is if any one of the act is amended, the new act only will be followed. Okay, as per this, according to the Criminal Law Amendment Act 2013 onwards, we have to follow section 376 subclass 1, the fresh one. So as per this section 376 subclass 1 explain about whoever, except in the cases provided for by subsection 2, commits rape shall be punished with imprisonment of either description for a term which shall not be less than 7 years but which may be for life, or for term which may extend it to 10 years, and shall also be liable to fine unless the woman raped is his own wife and is not under 12 years of age, and in which case he shall be punished with imprisonment of either description for a term which may extend it to 2 years, or with the fine, or with the both. Here, provided that the court may, for adequate and special reasons to be mentioned in the judgment also, imposes a sentence of imprisonment for a term of less than 7 years. So, section 376 subclass 2 explain about following subdivided. Okay, A, being a police officer commits rape under subsection 1 within the limits of the police station to which he is appointed, or number 2, in the premises of any station, that means station house, whether or not situated in the police station to which he is appointed, or number 3, on a woman in his custody or in the custody of police officer subordinate to him. And section 376 subclass 2 subclass B explain about being a public servant takes advantage of his official position and commits rape on a woman in his custody as such public servant or in the custody of a public servant subordinate to him. Or section 376 subclass 2 subclass C, being on the management or on the staff of a jail, remand home, other place of custody established by or under any law for the time being in force, or of a woman's or children's institution takes advantage of his official position and commits rape on any inmate of such jail, remand home, place or institution. And section 376 subclass 2 subclass D explain about being on the management or on the staff of hospital takes advantage of his official position and commits rape on a woman in that hospital. Or section 376 subclass 2 subclass E explain about commits rape on a woman knowing her to be pregnant. Or section 376 subclass 2 subclass subclass F explain about commits rape on a woman when she is under 12 years of age. Okay. Or section 376 subclass 2 subclass G explain about commits gang rape. So the above following crimes shall be punished with rigorous imprisonment for a time which shall not be less than 10 years, but which may be for life, that means life imprisonment, and also be liable to fine. Okay, provided that the court may, for adequate and special reason to be mentioned in the judgment, impose a sentence of imprisonment of either description for a term of less than 10 years. And explanation as per this section 376 subclass 2 of new provisions. Explanation 1 is sorry. Number 1, where a woman is raped by one or more in a group of persons acting in furtherance of their common intention. This is the main reason, common intention. Okay, and each of the persons shall be deemed to have committed gang rape within the meaning of this subsection. And explanation 2 of this section 376 subclass 2, women's or children institution means an institution whether called an orphanage or home for neglected women or children or widow's home, or by any other name, which is established and maintained for the reception and care of women or children. And section 376 subclass 2, subclass explanation 3, explain about hospital means the precincts of the hospital and includes the precincts of any institution for the reception and treatment of persons during convalescence or of persons requiring medical attention or rehabilitations. Okay students, and also we'll discuss regarding this section the main ingredients. What are the main ingredients will apply here? Number 1, the two things we need. Number 1, sexual intercourse by a man with a woman. Number 2, the sexual intercourse must be under circumstances falling under any of 6 clauses of the section. Okay, that is 2 is very very important. Okay students, and also the criminal amendment, the Criminal Law Amendment Act 1983 amended based on this Madura case, a leading Madura case, because the custodial, not custodial woman rape, the complainant gave complaint. At the time of inquiry, the police officials commit rape. Okay, so in this Madura case, a leading cases, at the time of opposition was made by the social persons and our Indian society, women's also, and also in this case acquittal of policeman in the infamous Madura rape case. Okay, here, and the national-wide protest against the verdict lead to the 1983 amendments to the rape laws in India. Section 375 and 376 of IPC have been substantially changed by the Criminal Law Amendment Act 1983, Act 43 of 1983. Okay, the same act has also introduced several new sections, that is section 376A, 376B, 376C and 376D of IPC. Okay, of this section 376A explain about punishes sexual intercourse with the wife without her consent by a judicially separated husband. And section 376B explain punishes sexual intercourse by superintendent of jail, remand home, etc. and with inmates in such institution. And section 376 subclause sorry 376b punishes B. 376b punishes sexual intercourse by a public servant with woman in his custody. And section 376 subclause C explain about punishes sexual intercourse by superintendent of jail, remand home, etc. with inmates in such institution. And section 376 subclause D explain about punishes sexual intercourse by any member of the management or staff of your hospital with any woman in the hospital. Okay, these are the new sections were introduced with a view to stop sexual abuses of women in custody and care and control by various categories of persons which, though not amounting to rape, were nevertheless considered highly reprehensible. The amendment of section 376 IPC now prescribes a minimum punishment of 7 years imprisonment for the offence of rape for combating the vice of custodial rape on pregnant woman, rape on girl under 12 years of age, and gang rape a minimum punishment of 10 years. Okay, 10 years of imprisonment has been made obligatory. However, for special reasons to be recorded in the judgment, the court in either case can impose a sentence lesser than 7 years or 10 years as the case may be. That is inherent power of the court. Okay, if court satisfied, he will do. And further improvement, the law relating to sexual offences can be found in the provisions of section 228A of Indian Penal Code, section 327 subclause 2 of Criminal Procedure Code, and section 114A of Evidence Act, which were introduced by the Criminal Law Amendment Act 1983. Provisions for trial is in camera method. That means in camera method means the judge's chambers, not open court and all. Okay, the section 327 subclause 2 CRPC and against disclosure as to as to identify of the victims of sexual offences as in section 376, 376A, 376B and 376C and 376D of Indian Penal Code. And section 228 of IPC not only protect the honor of sexuality, not only honor of sexually victimized women, but also make it possible for them to depose in court without any fear of social ostracism. Okay, OSTRACISM, ostracism. And section 114A Evidence Act, by raising a presumption as to absence of consent in cases of custodial rape, rape on pregnant women and gang rape in clauses section 376 subclause 2 of subclause A, subclause B, subclause C, subclause D, subclause E and subclause G. Okay, and merely on the evidence of the ravished woman as at least partially removed the infirmity from the evidence of victim of rape that was either too unjustly attached to her testimony without taking note of the fact that in India, unlike the Occident, not accident, Occident, 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 a disclosure of this nature is likely to ruin the prospect of the girl's rehabilitation in society for all times to come and unless her story was painfully true, she would not have taken such a grave risk merely to malign the accused. Moreover, in case of rape, particularly custodial rape, it is almost impossible to get any other independent evidence to corroborate the testimony of the prosecutrix. It has also to be remembered that a husband cannot be prosecuted for committing rape on his own minor wife below 15 years of age. If more than 1 year has elapsed from the date of the commission of the offence, that is section 198 of Criminal Procedure Code, subsection 6. Okay, and based on this, in writ petition before the court, the Supreme Court addressed itself to the problem of sexual abuse of children as a rising phenomena and how to interpret the relevant provisions. In the case of a rape on a girl of 4 years of age, the court said that even the slightest degree of penetration of the vulva of the penis, with or without emission, would be sufficient to constitute rape. Considering various aspects of the crime, the Supreme Court decided or declared it to be a crime against basic human rights. It is violative of the victim's fundamental right under Article 21 of the Constitution. The court should deal with the cases of sexual offences against women sternly and severely. Therefore, her testimony can be acted upon without corroboration in material particulars. And also, the Criminal Law Amendment Act 2013, a latest case in Nirbhaya, okay, as per our IPC, and recently the Nirbhaya case, accused was hanging, death punishment was given by our Indian government, that means Supreme Court. Okay, what happened in this case, Nirbhaya Act, the December 2012 Nirbhaya rape incident and the national-wide protest forced the government to constitute Justice J.S. Verma Committee to recommend changes in the existing rape laws. It is based on the recommendations of Verma Committee. These amendments were introduced. The Criminal Law Amendment Bill was passed by the Lok Sabha on 19th March 2013 and by the Rajya Sabha on 21st March 2013. The bill received presidential assent on 2nd April of 2013 and came into force from 3rd April 2013. And it also introduced major amendments to the Indian Penal Code and Code of Criminal Procedure Code also. The Code of Criminal Procedure Code 1973, the Indian Evidence Act 1872 and Protection of Children from Sexual Offences Act 2012. They amended. Okay students, I will give you section 376 of class 2, graver. What is the meaning of graver under this section? Offense under section 376 of class 2. That means it has been held that the results of the amendment of 1983, in that the offences listed in the section 376 of class 2 of IPC are graver in nature, and therefore it is necessary that the charge under the subsection should be distinctly recorded, and also reasons for conviction should be recorded. And also I just wanted to give the meaning, 2 or 3 provisions. Rupture of hymen. The victim was a young girl of 6 years, only 6 years childhood. Okay, it was quite likely that full penetration had not taken place as the accused was a grown up boy of more than 20 years. Okay. Here, injuries clearly indicated that rape as defined in section 375 of IPC had taken place. The court relied upon the assertion in medical jurisprudence that when the victim is of tender years, that is 6 years, rupture of hymen is not an essential consequence, right? In another case, we'll take where the hymen has remained intact but it had become red and also there was swelling. The medical opinion was not definite. So the court considered that, and courts said that even a slight penetration was sufficient to constitute rape. The redness of the hymen would not have been possible without penetration to some extent. Okay student, and first class we'll see and discuss with the first class of the section against will, against her will. That means first clause means the first ingredients of this section. Okay, against her will. What is meaning that against her will? The prosecutrix stated that first offending act was done despite her resistance, but subsequently she became a consenting party because of remitted promises of marriage. In the FIR first information report, she stated that she surrendered before him even at the time of the first act because of the promise of marriage. So the court therefore held that her version was not reliable. And the second clause, okay, not class, clause, 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 under subsection, without consent. So based on this section, without consent means it is no defense that the woman consented after the act. Consent as a defense to an allegation of rape requires voluntary participation, not only after the exercise of intelligence based on the knowledge of the act, but after having freely exercised the choice between the resistance and assent. Okay, resistance and assent, ASSENT, assent. So helpless resignation in the face of the inevitable compulsion or passive giving is in no consent. In leading case, Tukaram case, okay, Tukaram also a rape case, which is commonly known as Madura rape case, okay, where a constable was accused of raping a girl at the police station. The Supreme Court negativated such a plea of passive submission in view of the facts and circumstances of the case and acquitted the accused. Okay, but lower court was admitted, gave conviction. The accused police person to appeal before the appellate court, that is Supreme Court. The Supreme Court, what happened? Supreme Court acquitted the accused. So these are all typical situations in our Indian society. This is the main reason our lawmakers to amend the act. Okay, many people are protesting against this judgment. So we know really what happened in court. Without proving if any evidence, what happened? Automatically dismissed, that's all. So we need material evidence. Based on this material evidence only, passing the order. It's correct. This is in our system. And also, the accused, it must however be said that now in custodial rape of this kind, if the girl says that she did not give consent, the court shall presume that she did not consent. Okay, as per the section 114 subclause A of Evidence Act. Based on this presumption, the case was dismissed, not be dismissed, acquitted. Okay, released from the offense. Okay, students, and also I just wanted to give another subheading in this portion: consent on promise of marriage. Consent on promise of marriage. What is that? Consent on promise of marriage. Here, consent may be express or implied, directly or indirectly. That is, express or implied, or coerced, sometimes compulsion, threatening, you know very well, coerced or misguided, obtained willingly, or thorough deceit. Consent is an act of reason accompanied by deliberation, the mind weighing as in a balance the good and evil on each side. There is a clear distinction between rape and consensual sex, and in a case like this, the court must very carefully examine whether the accused had actually wanted to marry the victim or had malified motive. You just think about malified motive, and had made a false promise to this effect only to satisfy his lust. Okay, as the latter falls within the ambit of cheating or deception. You know meaning of the cheating and deception and all. We already discussed the earlier video. There is a distinction between the mere breach of a promise and not fulfilling a false promise. Thus, the court must examine whether there was made at an early stage a false promise of marriage by the accused, and whether the consent involved was given after fully understanding the nature and consequences of sexual indulgence. There may be a case where a prosecutrix agrees to have sexual intercourse on account of her love and passion for the accused, or not solely on account of misrepresentation made to her by the accused, or where an accused on account of circumstances which he could not have foreseen or which were beyond his control was unable to marry her despite having every intention to do so. Such cases must be treated differently. An accused can be convicted for rape only if the court reaches a conclusion that the intention of the accused was malified. Okay, the accused was malified, and that he had clandestine motives. That means bad motives. The acknowledged consensual physical relationship between the parties would not constitute an offence under section 376 of IPC, especially because the complainant was a major on the date of the occurrence. In the event that the accused promise is not false and has not been made with the sole intention okay, to seduce the prosecutrix to indulge in sexual acts, such an act would not amount to rape. Thus, the same would only hold the prosecutrix under a microconception of fact to the extent that the accused is likely to marry her, submit the lust of the accused. Such a fraudulent act cannot be said to be a consensual so far as the offense of the accused is concerned. Okay, you know very well meaning of the consent. Okay, consent. Consent means IPC does not define consent in positive terms, but what cannot be regarded as consent is explained by section 90 of IPC, which reads as consent gives first under fear of injury, and second under misconception of fact is not consent at all. That is what it is explained in first para of section 90 of 90 of Indian Penal Code, there are two grounds specified in section 90 which are analogues to coercion and mistake of fact, which are the familiar grounds that can vitiate a transaction under the jurisprudence of our country as well as other countries. The factors set out in the first part of section 90 of IPC are from the point of view of the victim, and second part of section 90 of IPC enacts the corresponding provision from the point of view of the accused, and it envisages that the accused has knowledge or has reason to believe that the consent was given by the victim in consequence of fear of injury or misconception of fact. So thus the second part lays emphasis on the knowledge or reasonable belief of the person who obtains the tainted consent. Okay, the requirements of both the parts should be cumulative satisfied. In other words, the court has to see whether the person giving the consent has given it under fear or misconception of fact, and the court should also be satisfied that person doing the act, that is, the alleged offender is conscious of the fact or should have reason to think that, but for the fear or misconception, the consent would not have been given in the scheme of section 90 of IPC, which is coached in negative terminology. As observed a leading case, Dilip Singh, that is Dilip Kumar versus State of Bihar. Dilip Kumar versus Bihar case. Here, section 90 of IPC cannot be considered as an exhaustive definition of consent for the purpose of Indian Penal Code. The normal connotation and concept of consent is not intended to be excluded. Submission of the body under the fear or terror cannot be construed as a consented sexual act. The consent for the purpose of section 375 of IPC requires voluntarily participating not only after the exercise of intelligence based on the knowledge of the significance and moral quality of the act, but after having fully exercised the choice between resistance and assent. Whether there was a consent or not is to be ascertained only on a careful study of all relevant circumstances of the case. Okay, and also where the accused has sexual intercourse with the prosecutrix by giving false assurance to her that he would marry her, and when she became pregnant, he refused to do so. It was evident that her never intended to marry her and procured her consent only for the reason of having sexual relations with her, which act of accused falls squarely under the definition of rape, as her consent was obtained under a misconception of fact. Okay student, that's all. This is section 376 of IPC and section 375 of ingredients also. Okay, and also I just wanted to give the Evidence Act. We already discussed amendment of Act 111 subclause A of Evidence Act. The Act explained about amended Criminal Law Amendment Act 1983, and section 114 was incorporated, which imposed the burden of proving, that is consent, upon the accused in the cases of aggravated rape. This was an exception of the general rule of presumption of innocence of the accused. By the Criminal Law Amendment Act 2013, the old section was substituted on the recommendation of Justice Verma Commission, which results as follows. What is this? Section 114A Evidence Act, presumption as to absence of consent in certain prosecution for rape. This is recommendation of Justice Verma Committee. Okay. In a prosecution for rape under Class A, Class B, Class C, Class D, Class E, Class F, Class G, Class H, Class I, Class J, Class K, Class L, Class M, Class N of subsection 2 of Section 376 of IPC, where sexual intercourse by the accused is proved, and the question is whether it was without the consent of the woman alleged to have been raped, and such woman states in her evidence before the court that she did not consent, the court shall presume that she or he did not consent. As per this provision of this explanation in section, sexual intercourse shall mean any of the acts mentioned in the class of A to C of the section 375 of Indian Penal Code. Okay. Okay, students, I am closing this session and we'll discuss with another section with another class. Okay. Stay on the line. That means stay with your legal mind and send your feedback. Okay. Watch regularly in this YouTube classes also, and also subscribe. Those who are not subscribed up to now, please subscribe immediately. Why? Because daily I am updating videos daily. Okay, minimum 5, maximum 10 videos updating. Those who are subscribed, automatically it will come in your subscribed area, that is your mail and all. Okay. Okay, students, take care and read properly and improve your knowledge, achieve your goals. All the best. Smile. Best of luck.